Clare Curran.
Thank you, Mr Chair. I think Chris Bishop described this bill as small and useful, and the Labour Party would agree. And we support it. It corrects an anomaly in legislation, and that's always an important thing to do. It stems, and I won't go into too much depth on this, obviously it's been traversed before, into an outcry around the restriction of the total restriction on into the river. The book written by Ted Dorr in 2015, and it corrects that anomaly in around interim restriction orders made under the Films, Videos and Publications Classification Act. In the Select Committee discussion, I didn't sit on the Select Committee, but in reference to the commentary back from the Select Committee, there's essentially two changes that are being made. One is to the title, doesn't relate to Part 1, Mr Chair. The second is to is the insertion of new Clause 6, adding Clause 6, a new section under 133A in the Principal Act, and the member Chris Bishop has just touched on that around the introduction of new offence provisions for interim restriction orders. That would, and basically that what appears to me is that that the existing penalty that for breaching an interim restriction order would also apply to breaching any of the new type of orders. Now, because I didn't sit on the Select Committee, I'm not quite sure what the Principal Act offence provisions are that are not envisaged by the more flexible interim restriction orders proposed in this bill. So maybe the Chair might like to just answer that. Not the Chair, Mr Chair. Apologies to you. I'm sure that you could have a go. I'm sure you could answer it. With your hands tied behind the back. But the member in charge of this bill, Mr Bishop. I also just like to refer to the submission by the Censor's Office, or the Office of Film Literature Classification, the office, which is an important office, and they gave a considered submission. They referred to the unprecedented public outcry at the imposition of the interim restriction order, which the president of the film, what's its name? The Film Classification Board had no option. His hands were tied. He had to impose that total restriction during that period of time. But there was a considerable public outcry, and the office, the Chief Censor's Office, really said that had this amendment, had this amendment been in place in August 2015, the President could have issued a more nuanced interim restriction order. And of course there's no guarantee that would have been done, but this anomaly being corrected allows for that to occur, and for instance it could have continued with the R14 classification, which meant that libraries could have still issued the book and there wouldn't have been the public outcry. But I also note that, and my closing remarks are, Mr Chair, that the member in his various speeches on this bill has raised the issue, and I think the censor sort of goes there to some extent as well in his submission on this bill, raised the issue of the concept of the interim restriction orders and whether it was timely for a review of those. And clearly this bill doesn't go there. He just deals with just a small anomaly, which Labor supports. But I think that, I'd like to see the member bringing another member's bill maybe next year when he's in opposition to actually address the bigger issue of interim restriction orders and whether they could be reviewed, and the role of the Film Censorship Board in actually carrying out those orders.
The question is that Part 1 stand part. John O'Naylor.
Thank you, Mr Chair.